everybody. Thank you for joining us today. The title of the seminar, it covers part of the material that we may talk about today. In fact, I'm planning on probably doing a full seminar just on billing audits. I really view this as the big issue that's coming up for 2021. And I'm going to touch on that, a little bit of that today. But we're really seeing, especially in the with managed care and private insurers now challenging payments and taking new routes to try and recoup payments from our provider clients. We're seeing this from everything from personal injury type insurance coverage to telehealth and home health, a lot of different areas. We are currently involved in several disputes with insurance payers. So that's going to be a hot topic that we'll probably cover in depth in a future webinar. Our subject matter for today, of course, we'll give a little update on telehealth. We saw some changes arise with COVID, and they are probably going to stay permanently with us for the most part. Non-compete agreements, we tossed this in here. Frankly, this month, we're in between one that we did last month and then another one that already got scheduled for next month for one of these afternoons. And the non-competes, this is something probably we are seeing most commonly in our office right now. I am almost always talking to one or two, oftentimes it's physicians, but sometimes other folks, about enforceability of non-compete. So I thought maybe we would touch on a couple issues here that might be helpful for our folks in the audience if you're looking at these issues, particularly the statutory changes and how that affects physician providers since those changes came into Florida law. Business partnership issues. This is another one of those issues. I just got a quick slide on it, but I want to talk about it because it's something that comes up all of the time. People get together and do business together, and then they separate. And it's shocking how unprepared for separation they are, or how unprepared they are to deal with disputes in their practice. And I want to touch on that a little bit. Again, the billing audits and disputes. Stark and anti-kickback statute updates, item number 5 here. This is another late addition. We may, depending on demand, I'd like to hear from the folks that I'm talking to today and other folks, if you could maybe drop something into the comments or maybe on LinkedIn or some social media. Let me know if this is of interest to cover in an hour-long topic. There was substantial updates and amendments to the anti-kickback statute and Stark law, particularly the exceptions and safe harbors that were drafted into law at the end of 2020 and became law in 2021. And as I was putting this presentation together, somebody was asking me about a couple of these issues just generally, and so I just want to touch on that and let people know what those changes are all about. And then finally, I wanted to put something fun in here. A lot of this stuff is pretty dry, so if we have time at the end, then I can talk about a couple issues that came up recently with respect to our asset protection practice. This comes into play a lot because we represent a lot of people who are in a high-risk area at risk of being sued. And if you do get sued, what are your options after insurance, or if you don't have insurance to cover, or even if you do, and asset protection always finds a way into the conversation. So with that, with no further ado, I will press on. First, talking about telehealth and some of the what I think are, what I'm going to talk about are unresolved or unanswered questions about the new telehealth statute. So you'll find our Florida telehealth law promulgated in 456.47 of the Florida statutes. That statute, it's not very long, and it describes telehealth as a synchronous or asynchronous communication where healthcare providers serve patients from remote settings. Sounds easy enough until we dig into the definition of what does synchronous mean, what does asynchronous mean. Synchronous generally means communication that occurs in real time. That's my read on the statute. Asynchronous means communication that does not occur in real time. It's also often referred to as store and forward type communication. So this might be taking photos. Think of traditionally x-rays. You get an x-ray, or you get an MRI, or some type of images done. You may not talk to the physician who is responsible for those x-rays. You may talk to your primary care provider, whoever whoever ordered the films. but you are looking at information, and the physicians are often making determinations based on information where it's not a real-time conversation, it's information that's been captured and forwarded. Of course, now in the modern era, we have a lot more things that we can do with technology, including capturing videos and phone calls and photos. And with COVID last year and a little bit of a loosening up of the communication standards where we could have folks provide and receive telehealth services, there are new questions on what qualifies as an asynchronous communication for the telehealth law, both what's permissible under the law and what is compensable from insurance companies or other third-party payers. This is an unanswered question. I can't go too much into it because I'm involved in some litigation right now in federal court where this is one of the questions that has come up in the court case. I can say that the statute does tell us that you cannot have a simple phone call with a patient and that will not qualify as telehealth services. That standard was relaxed for the pandemic, where we did allow people to receive and provide services by a phone call, but under the telehealth law and traditionally under telehealth, just a phone call with nothing more is not going to suffice. There does become a question if you have a phone call, for instance, coupled with images, or a phone call coupled with some other type of data that is transmitted, will that qualify for telehealth? And where this becomes important is not only in the licensing aspect and what's permissible for providers, and there are several, I refer to physicians, but lots of folks are qualified to provide telehealth services, including mental health and other services. But this question of synchronous and asynchronous also comes up not only with the providing of the information, but what the insurance companies will pay for. So if you have further questions on that, I can't get into detail, of course, right now on it, but I can give you lots of information and why my interpretation of asynchronous may be a little bit broader than what some other folks believe. So here, this is what I've essentially talked about here with the statute, with synchronous communication being real-time, face-to-face, and we use these terms, by the way, in telehealth, face-to-face or real-time, face-to-face video conferencing. Even though it's not live in person, we've actually drawn a distinction as we talk about this in practice between a live conversation that occurs where two people are sitting in the same room and a face-to-face conversation which can occur over Zoom or Skype or the way that I'm speaking to you today. So we've really seen a lot of changes, a pretty fast movement towards Zoom-type communications or remote communications over the past year, and of course that's going to affect the way that we provide services, not only in my business of law and the way that I can present today, but also in healthcare, of course. And so to wrap up a discussion here on the telehealth and how to read that statute today, a key issue is to make sure that if you're going to provide telehealth services either in Florida or to Florida patients from another location, and that can be an out-of-state practitioner who registers under the Florida telehealth law, and I'll cover that in a moment, but if you're going to provide services, you want to make sure that you are complying with the communication modalities in the statute so that you can make sure that your practice is compliant and it's, again, compensable. How do you register? Well, the licensing and registration process for telehealth is pretty straightforward. The statute sets out the requirements where you can fill out an application. If you're not a Florida practitioner, but you want to serve patients in Florida, you fill out your application. You have to have an unencumbered license from another state. You have to demonstrate financial responsibility, and this is done by having either one is a separate financial component, but primarily through either having insurance coverage or a letter of credit that's in compliance with the statute. And I forget what the numbers are, but the requirements are in the statute. And then you have to designate a Florida registered agent. And this is just a process of designating somebody that if you're going to be served with legal process in the form of a summons, or if you're served with a subpoena, you have to have somebody in the state of Florida who can receive that for you. You cannot, if you're an out-of-state practitioner, provide services to Florida and then open a Florida office. You would need to get licensed in Florida to do that. And then again, some of these standards were relaxed by the pandemic, but we do not expect those changes, those relaxed standards, to stay. It's not difficult. I've run it. I'm involved in a case. Again, this is one of these issues where a case that I am involved in with telehealth. There are several physicians and some from out of state who are not Florida licensed, and I don't know why they didn't register. To me, it seems like a pretty straightforward and simple process. It's easy to check to find out who has been registered in Florida. We do not have a broad registration yet where a physician provider can register under a national compact, but we do have that we have it for nursing, for some nursing, and some other professions have a national compact where once you join that compact, you can provide services anywhere. But here in Florida, you have to register under the statute if you're going to serve Florida patients. And the general rule from state to state is wherever the patient sits is the law that you're going to be subject to. So if you're in Florida and you want to serve patients in Missouri, then you're probably going to be subject to Missouri law. Again, if you're somewhere else serving Florida patients, you're going to be subject to Florida law regardless of where you reside and where your license exists. I am not going to spend a lot of time on the payment issues, other than to say that the standards have been relaxed, but we do not have payment parity yet for private insurance companies here in Florida. But the physicians can be paid, and most have now incorporated this into the practice, where physician providers can be paid for more services than they would have been able to be paid for before. I mentioned earlier that that we saw the relaxed standards as far as communication modalities. And we've also seen relaxed standards as far as pre-existing relationship requirements and cost sharing, co-pays, and so forth for providing telehealth services. Again, the pandemic really brought about a modernization of our ability as a policy, of the ability for folks to receive telehealth services and for providers to provide those services and be paid for them. There are still some disputes, and one big issue right now is the payment parity. I've got this on the next slide. And that essentially is, do you get paid from an insurance company the same amount for telehealth services as you do for in-office services? The Florida Medical Association has tried to put pressure on the insurance commissioner to enact the payment parity law. Some states have that. Florida does not, unless it's changed recently. To my knowledge, Florida still does not have a payment parity law. And if you think about it from a policy perspective, it's kind of an interesting question, because on the one hand, if you're providing the same service, what difference should it make? A lot of us provide services. Me as a lawyer, I have several clients that are outside of Central Florida that I deal with on a regular basis that I hardly ever see in person. We're usually communicating by call or email or some type of remote communication. And I don't feel like the advice that I give should be compensated any less because I'm not meeting somebody in person. But the other side of that coin is that the insurance companies figure that when they are providing payment for services, they're providing part of that payment is for all the overhead that goes into running a physical medical practice. And if you don't have that overhead and you're simply able to provide treatment through a phone call or through video communication, and you don't have the same overhead, that the compensation rate should be lower. I'm not going to take one position or the other on that. I have some opinions on it, but if you have questions about that and you want to talk about it further, please do contact me and let me know. And if anybody hears of any updates on that, you could shoot me a quick message. I'd appreciate that as well. If you have questions, by the way, as I'm going through this, please don't be afraid to drop something into the dashboard panel here. And I'm just looking to see, I saw something pop up with a hand up. I see a question that I'm going to touch on here in a few minutes that actually has to deal with, it's in the Stark section. So I'll talk about that in a few minutes here. I am going to cover that. But if you have any other questions and something that I can answer, please let me know. Now I'm going to jump into the next topic here. just for a couple minutes, because this is probably the issue on a day-to-day basis that we always have some issue going on with employment agreements and non-compete agreements. And in healthcare, everybody knows here in Central Florida, we have a few major healthcare companies. There's a lot of healthcare, smaller healthcare companies, a few major ones. Almost everybody that I talk to wants either if they're employing providers, they want to have those folks on a non-compete agreement, or if they are working for somebody they are subject to a non-compete agreement, it does put on some handcuffs as to what they can do if they stop working for that particular employer. So I thought it'd be useful just to touch on it here at a high level, and then a change that we've seen recently and where the policy seems to be going. So I'm going to actually make a prediction. So we start with the premise in Florida that any agreement restraint of trade is unlawful, and that would appear to be an employment restriction that says that you can't leave work somewhere and go to work for someone else. There's also a public policy issue, because when it comes to healthcare, when we limit people's ability, providers and professionals' ability to provide services for other employers, we could potentially limit access to healthcare, and that could be a problem. And so there's also the other side of that coin, where certain companies spend time and effort and money building their business, building their reputation, maybe on marketing activities to develop loyal clients and referral sources. And those folks have an interest in protecting their interest in those sources and not hiring, for instance, a new physician, maybe from New York, who comes here to Florida and then works for 6 months and then wants to go out and open up their own practice or go to another practice, and can now do so and command more compensation because they have a base of patients or referral sources who are going to follow them. So it's a balance between two competing interests. Florida recognizes that balance and basically says that if you have a legitimate business interest and a legitimate policy concern, and you meet certain requirements, you can restrict people's ability to work in competition with you after their employment. These are restrictive covenants serving a legitimate business interest, and they have to be limited in time and in geographic scope. Again, they also cannot violate the public interest. So what we normally see is a non-compete agreement that says that you can for a limited period of time, somewhere between 1 year and 2 years, someone who leaves employment, a physician who leaves a practice, can't work within a certain geographic radius of another practice. Now, a lot of that can become, especially when it comes to the geography, there's a lot of gray area in there. Let me tell you why. For those of you, the lawyers will know this, but I know there's a lot of non-lawyers on. The reason we always see 1 year or 2 years, because the statute says that anything under 1 year is presumptively reasonable, and anything over 2 years is presumptively unreasonable. So that's why you typically see 1 year or 2 years. It's not that everybody's just agreed that's what amount of time we want to non-compete. I'm sure if the statute said that anything under 5 years was presumptively reasonable, that's what we would see. And in fact, that's what we do see in connection with the sale of a business. That's different than an employment agreement type non-compete. When you sell a business, of course, the buyer of that business doesn't want to be in competition with you a year or two from now, so we're allowed to extend out those non-compete provisions for a longer period of time. Under the employment context, another issue is if somebody's violating the non-compete and the employer doesn't find out about it for 6 months or a year, does the employer still have a right to enforce the non-compete and stop the former employee from working? That will often depend on whether or not there's a tolling provision in the agreement. If there's no tolling provision, then they may not be able to do so. Another issue that comes up oftentimes is if the employer breaches or is alleged to have breached the agreement first, will the employee be able to get out of the non-compete? We get that question a lot. Sometimes it depends on the language in the contract, whether or not there's separate covenants or dependent covenants. This gets into a little bit of technical legal issues, and perhaps maybe we'll take a whole seminar and talk about non-competes. But the general rule is that if it's reasonable in time, and then you have a reasonable geographic scope. This might be a certain mile radius is what we often see. We sometimes see maybe a county a certain region, a metropolitan area, or we'll see a mile radius from any existing office. There becomes a question there. The question that comes up sometimes is whether that's an office that exists at the time the agreement is signed or at the time the employee leaves. But these are all questions, and the overarching question that surrounds all of this is whether or not the employer is seeking to protect a legitimate business interest, and preventing competition is not a legitimate business interest, but protecting relationships very well may be, specialized training very well may be, and then whether or not that non-compete violates public policy concerns, and limiting access to healthcare can violate a public policy concern. So that's the big picture of non-compete agreements in Florida, and it leads into the fairly, now the law's been on the books for a little over a year now, but it's still a new law, relatively speaking, in Florida with non-competes, and it pertains to medical and osteopathic physicians who are in a medical specialty practicing in a county where only one entity employs all of the specialists. And the new statute 542.336 essentially says that that one entity cannot lock up all of the specialists in the county, so that a non-compete agreement would not be, it would not serve the public policy. And the way they wrote the statute makes it pretty clear that this isn't a situation where if you had an agreement that was enforced before the statute came in place, it would be grandfathered in, because the law says that as a matter of law, any agreement where there's a specialist group who employs all of the specialists in the county does not serve the public interest. Then under the standard for enforcing non-competes, we're not going to be able to enforce that particular covenant, regardless of when the covenant was signed, before or after the statute. This has been tested in a federal court case. The statute survived, and that's the law as we see it today. And why I mention this as well is that I believe this law of Florida is well known. I get a lot of calls from people from other states is thinking about signing employment agreements. We have a lot of and I talked to a lot of these folks, a lot of quality people looking to move to Florida, physicians and other healthcare providers, and they are looking to come to Florida, and they want me to look at their employment agreement. I do this frequently, and the big issue is always the scope of the non-compete in the employment agreement. And as we talk through this, they want to know, is this thing enforceable? I've heard employment agreement restrictions, non-compete restrictions are not enforceable, but in fact in Florida, we are a state that enforces non-compete agreements, perhaps more so than anywhere else. Other states are more and more, we're seeing them either be deemed unlawful as a matter of law. We are seeing what's called garden provisions. There's a couple states now that have garden provisions. I think Massachusetts was either talking about this or may have implemented it, which essentially says that you can enforce a non-compete agreement, but you have to continue to pay the former employee not to work, and it's got to be some reasonable amount. It doesn't be their full salary, but it has to be something reasonable. I prefer, unless there's really an issue with the competition, if it's really something where the competition is hurting the employer, if the employer is my client, I much prefer to enforce non-compete violations through monetary damages, some type of payment based on business that's taken by the person leaving. I also prefer other provisions that are not as restrictive as non-compete provisions, such as non-solicitation clauses, anti-piracy clauses, and things of that nature. So I think there's a lot that you can do to follow what I believe is a national trend towards people moving away from non-compete. And I think we're going to see that this ties in nicely with the telehealth question. Now, if you are providing telehealth services, presumably you can do that throughout Florida and maybe in other states as well, but certainly throughout Florida very easily with a computer setup like I'm speaking to you now. Where is the reasonable geographic scope if an employer paying me to provide this service wants to create a non-compete restriction? And that's right now sort of a gray area, unanswered question, but it's one I certainly expect to see, and we'll have to answer that. And let's see, I think I covered, sorry, I'm going to move past a couple of these slides because I want to be able to cover this other material. I really covered all this while I was talking about non-competes. And I want to move into our next topic. I'm going to talk about this briefly, and this is not really, it comes up a lot in healthcare practices. It's not a healthcare issue, but again, it's another one of these issues that I see so frequently. And I've been involved in a lot of litigation and threatened litigation with healthcare practices and dental practices and other types of businesses where people start off, they go into business together, and then they realize that they can't live with each other for the long term. It's much like a marriage. They need to separate, and then we start talking to them. And actually, I just was on the phone with somebody yesterday, and they've been an owner of a company for several years. I believe they were an owner. As we dug in the records, we found that they are, in fact, recognized as an owner. Never really paid attention to the corporate issues and the back office stuff. It just really was performing as a worker bee. Never got any information, and now there is, in this particular case, is a problem with the IRS. It's a big problem with the IRS. And when we're trying to look and go back and say, okay, well, what do you own? What's your ownership interest in this entity and two other related entities, one that owns real estate that the business operates out of, and another one. When we try to figure out what people own, and we try to figure out what type of remedies they have if there's a dispute, there's a lack of documentation. And this problem can be avoided. Obviously, this is a little bit of a self-plug, but consulting with counsel, we do it, or get a lawyer that you trust and somebody to help document the relationship in the beginning. For an LLC, it's very simple, just to have an operating agreement or a member agreement or a shareholder agreement or something that documents the parties' roles and their duties and responsibilities generally, their ownership interest, and how to resolve disputes when they arise. A 50-50 relationship can lead to problems if one half of that 50% views a question one way and the other half views it entirely differently. So how do you resolve those? There's several ways that we can resolve those issues. We have buy-sell provisions that we typically put into operating agreements or shareholder agreements. We prefer the LLC form in the operating agreement. As far as breaking deadlocks, if you have a 50-50 situation, you can use tie-breaking authority. You can rotate that from one to the other, or you can bring in a third person, an advisor. You can have escalation clauses where the tie-breaking authority rolls up from the managers to a board of directors or other equity holders, ultimately to a parent company. You can appoint outside third parties. I try to resist this sometimes, but I have been asked to do this and have agreed in limited circumstances to be a designated person that would be part of a panel and essentially provide a swing vote. There's other alternative dispute resolutions, such as procedures such as mediation, arbitration, and of course then if all of that doesn't work, then you can have buy-sell procedures where the deadlock, and I don't like to initially have a buy-sell right away. I like to have a deadlock resolution, and if you don't get things resolved, then a cooling off period, and then maybe initiation of the buy-sell. You don't want people storming out the door just because people don't get along all the time. On the buy-sell, the most common one is to let one party declare a value that they'll buy or sell their interest for, and then the other side or the other partner of business, and this may depend on whether or not you're a 50-50 arrangement or some other percentage, but somebody declares a value, and then the other side gets to determine whether they want to buy at that value or sell at that value. It may be different if you're talking about 5 owners in a group practice and everybody's got 20% and they want to sell. It may be a situation where they can sell and the interest gets for the first option to redeem the interest by the company, and then it goes to the other shareholders. Again, this is only limited really by parties' creativity, and when you're talking to a lawyer who's experienced in this, but please do not let a deadlock in your healthcare practice or other business bring your business down because you spend the next 6 months to 5 years fighting over it in and out of court. All right, so this is what I think is the hot topic coming down the pike over the next several months, and I'm going to do probably in May or June. I'm probably going to dedicate an entire hour walking through this issue of the billing audits and disputes and recoupments from. We'll take a look a little bit at Medicare and Medicaid, but what we're seeing growing as a trend is the private payers, and we're seeing private payers who are refusing to pay, and some who are actually filing lawsuits to disallow or recoup claims for payment of services, sometimes because they claim the paperwork requirements weren't met, or simple audit requirements weren't complied with, and sometimes because they're claiming that the services provided are not legal. For instance, I mentioned earlier with the telehealth statute, if you are submitting claims to insurance and the insurance company believes that either your folks who are providing the services are not properly licensed or registered in Florida to provide those services, or if those folks think that the proper communication modalities or other requirements were not met, they may refuse to pay, and they may in fact try to seek recoupment of payments that were already made. They may not only refuse to pay you for your services, but for instance, if you are a physician who wrote prescriptions and they paid the pharmacy for prescriptions, or you wrote a prescription for some type of for a wheelchair and they paid that, they may come back and seek recoupment against the physician who wrote the prescription, who may have only been paid $100 to write the prescription for a $5,000 motorized wheelchair. And this is not an exaggeration. We have seen situations, and these are publicly filed lawsuits, some that we are involved in or have clients who've been involved in, where the recoupment claims are in the millions of dollars against individuals. We're seeing claims against medical directors. I see this situation a lot where somebody wants to open a medical clinic in Florida, and under the Healthcare Clinic Act, they're not a physician owner. They get a physician who's going to serve as a medical director, and next thing you know, the medical director is being sued because the company was not complying with whatever the requirements were in order to submit claims to insurance, and the medical director individually is on the hook. So what that all means is that we're seeing a trend towards the insurance companies refusing to pay and seeking recoupment, and the creativity of these claims continues to grow. So one that I saw recently was a private insurance company trying to extrapolate a certain portion of audited claims over a greater period of time and a greater period of claims. And so anybody who's been through this process with Medicare, for instance, knows that extrapolation essentially means that once the auditor takes a small sample of claims, if they determine that the error rate is high enough, they can extrapolate that figure, and what might be a $20,000 or $30,000 demand for recoupment that may be subject to some dispute. And by the way, these generally are. Every time I look at them, we find that as we look at things more closely, we usually don't agree with the assessment of the auditor, and so that starts some communication. But if the auditor thinks that the error rate is high enough, and if the numbers suggest that the error rate is high enough, now they take a $20,000 claim and they turn that into a $200,000 claim, because they say, if you were incorrect if we audit 10 claims and 8 of them are wrong, you're wrong 80% of the time, then we can assume that your last 1,000 claims, at least 80% were wrong, and now you owe us a couple $100,000. For some practices, this is very painful. For some practices, this could put them under. And we've dealt with that, and we're seeing it more and more, and I think it's going to continue to grow. The reason that we're seeing it, the justification, we've got this dynamic you have to understand between the payers and the patients and providers, and our clients, and I truly believe that our healthcare providing clients want to provide the best service. They are providing services, and they want to provide the best service for the patients. But there's a lot of fraud in the system. And in fact, I've gotten called now, and maybe some folks, I'd love to hear your stories. People are getting calls by companies calling me up and And the recent one was, do I have diabetes? And if I have diabetes, they can send me diabetes medication. And another one said, if my knees hurt, they can send me knee joints. This, I believe, is the opening salvo. If they're telemarketing me for diabetes medication or knee braces, this is the opening salvo to essentially a fraud, where they would get maybe some fraudulent doctor or maybe some unwitting doctor who doesn't know, and maybe they're giving them bad information. Who knows the reason why, but next thing that happens is a prescription gets written. I receive a knee brace that I don't need or some insulin that I don't need, and the insurance company gets billed for that, and now we have a lot of fraud in the system. The healthcare payers want to make sure that we are only paying for services that are provided, that are medically necessary and being provided to patients. And we want to make sure that those charges for those services are reasonable. The providers want to provide the best possible service, and they want to get paid for it. So when I look at these auditing claims, I always look at it from that standpoint. I've got a client who did the work, who wants to be paid, and I've got an insurance company that doesn't want to overpay. So how do we bring those parties together? And if you approach it from that standpoint, we actually find we're very successful once we get past the issue of, okay, there's no fraud here, we've just got services that need to be paid. Why are these insurance companies so focused on these fraudulent schemes? Well, one, for the reason I just told you. I got this phone call. I've received a few of them recently. And if you go back a few months, back on September 30th, 2020, there's actually, if you go on YouTube, you can search this out. It's about a half-hour press conference from the Department of Justice. They announced charges against several defendants across several states. And it was a massive telemedicine fraud scheme. It involved trading prescriptions. Essentially, they were getting people to get prescriptions, send them to the insurance company. We had opioids, we had pain creams that were involved, a lot of compounding for the pharmacies charge more to mix up these different concoctions to serve patients that don't need them for ailments that are either exaggerated or don't exist. But what's interesting about that September 30th announcement is several folks, healthcare professionals, I believe some probably were pulled into this unwittingly, lost their licenses, and it was the largest ever fraud scheme announced by the federal government. It kind of, I think, because of the pandemic, followed onto the radar, but it was huge. It's a $1 billion scheme. And because of this, we are, I think, now seeing more and more private payers follow in the shoes of Medicare and Medicaid in conducting audits and seeking recoupment and seeking to extrapolate these charges to recover funds that they think were not properly paid or compensable. So I talked a little bit here. The private recoupments typically start off with an audit letter. If you or you represent a provider and they receive an audit letter, at that point, there's usually somebody very knowledgeable in the practice who can gather the information necessary to respond to the audit letter. But you need to understand that in response to these audit letters, that you're now under a timeline. You need to respond fully, you need to respond with the information that's requested, in the form that it's requested, and you need to document that. You need to document when you send the information back, what information you are sending, and be prepared to send information. If you're a provider responding to one of these audit letters from an insurance company, you need to be prepared to send that back with half an expectation that that there's still going to be a recoupment claim. So you are now laying the groundwork. The lawyers will understand this. You are now essentially laying the foundation for what is going to be your ultimate appeal, so you can get paid for these claims. So the moment you get that audit letter, there should be a trigger. You should be calendaring the timeframes to respond. You should also understand your rights that are in your enrollment contract. The enrollment contract often incorporates manuals, and if you're dealing with, for instance, like a Medicaid managed care, we've seen quite a few of those. It also incorporates the statutes that govern that program, both at a state and federal level. And we'll see incorporated manuals and then the contract itself. Look at my notes here. If you, on the audit letters, make sure you respond to everything. Make sure you document everything in respect to the response, and also if you are, when you're sending this information back and your timing is correct, I said you're laying the groundwork for what might ultimately be your appeal, you want to know what your contract, how your contract reads with respect to dispute resolution procedures. Most of these contracts contain alternative dispute resolution procedures that might involve a negotiation, mediation, and/or arbitration. It may dictate what system of arbitration you're under. It might be AAA, it might be American Health Law Association, maybe something else. Arbitration might be binding or non-binding. Once you find yourself in this situation, the lawyer should look at this very carefully to know what the next steps are going to be. If we don't resolve, are we in an administrative proceeding? Is it judicial review? Are there alternatives? If you don't follow, like for instance with Medicaid, there's a state-run Medicaid dispute resolution system that might run parallel to the contract and its dispute resolution procedures. So you need to understand this and how you ultimately get the remedy that you're seeking, which is to get paid for the work that you did. All right, so this is the information I just told you. I put it here in the slide, so if you print these and you read them later, you'll get a chance to look. And I'm monitoring. I'm going to hit on, I think the next section hits on one of the areas that somebody has asked me to talk about briefly. And one other thing on these payer disputes, if you are, I mentioned earlier that in connection with the DOJ investigation and some of the cases that I've been involved with, I think there are a lot of honest players getting pulled into the system by less scrupulous players. Maybe somebody manipulates their relationship with maybe a pharmacy or maybe a physician practice to make representations about patients and prescriptions that ultimately could get the physician in particular into trouble. We also see this again with medical directors and clinics where they may be absentee and believe their duties and responsibilities are much less than what they actually are. These are just some common schemes that you should be aware of if you are involved in any of these, if you're in this industry involved in any of these issues. Wherever you see where a pharmacy is paying for prescriptions, that's going to be a problem. You've got kickback issues there, and you've got other potential regulatory issues. If you see a durable medical equipment company paying for prescriptions for DME equipment or giving any type of benefit or remuneration in connection with writing prescription for DME, you've got a potential problem. Where you have telemedicine companies who are paying the providers and the patients are not paying, or the representation that the patients don't have to pay, or that the patient services will be covered and the patients didn't reach out to the telemedicine company, but it's really a third party reaching out, you've got a potential problem here. Anytime you have a payment where people are being paid, if you have a physician who's being paid based on not on the appointments, but on the number of prescriptions, or being paid based on approving the prescriptions versus not, that should be, all of these should be huge red flags. Anything that you wouldn't do in normal practice, you can't generally do in a technologically advanced practice like a telemedicine practice or anything of that nature. And that's where we've seen this actually in connection with these telemedicine companies. We've seen a few of these now, including the huge criminal one. We've seen them from a civil liability standpoint, where you can get into a lot of trouble for non-compliant schemes, essentially. So if you are being evaluating whether or not to get involved with one of these services, you should be asking, follow the money. Who's paying? What am I being paid to do? Who's going to pay for that? How am I going to be paid? How much am I going to be paid? Does it sound reasonable? Is there insurance involved? And is there federal payment involved? Is Medicare, Medicaid, TRICARE, something of that nature? Especially when it's not cash payers paying for these services, when there's a third party paying for them, that should raise your antenna. And if there are federal payers, then that should double raise your antenna. All right, so somebody asked earlier about the Stark updates, and I've considered, I'd like to know, again, this is one of those items very dense. End of 2020, we got some updates to Stark and AntiKickback. It's a big deal in the health law community, but I haven't heard much of it outside. If this is an area of interest that you would like us to cover in more detail and spend an hour talking about these issues, the updates, and the updates pertain primarily towards modernizing the law in light of technology and encouraging value-based arrangements. So moving away from the fee-for-service arrangement that we've traditionally had and going to a value-based arrangement and encouraging entities that participate in a value-based enterprise to provide a bundling of services and to be able to do that without running into issues with respect to referrals. And when we talk about referrals, we're looking primarily at STARK, which is physician referrals for designated health services where the physician has a financial interest, or the kickback statute, which prohibits any payment or remuneration in exchange for referrals. If you think about any other business that operates, and this is taking this from a high level, if you think about any other business that operates, you're trying to provide efficient services. And so I'm talking to you today on my Microsoft computer, and Microsoft now, they want to expand their services and provide bundled services and do it in an efficient manner. And so we pay one price for SharePoint, and we've got all of the subscription services that come with our subscription, all the different software that we can use. Microsoft bought LinkedIn. I think I saw where they're looking at Nuance Communications. That's a dictation software. I think there's some number, $16 billion that they might pay for Nuance. The idea is to bundle these services and make it more economical and provide a better value to the client. And frankly, Microsoft, Apple, they've done a great job of doing this. Technology companies have been fantastic in this arena. In healthcare, the healthcare companies have been hamstrung by the fact that referring to having a network where you make referrals can potentially get you into trouble. And it's because of the Stark and the kickback restrictions. So these modernization, these updates that came into law here in early 2021 were essentially intended to encourage value-based arrangements where an entity can provide services to patients, and it's based on the results that are provided to the patients rather than a simple fee for services. Moving away from, I'm going to get paid for every diagnostic test, I'm going to get paid for every photo, every lab, every treatment, and every type of referral. And if I refer somewhere and I get a financial interest coming back, that can run into problems. Now we're going to take the patient who's got diabetes. I read an astounding number recently. 1 in 4 federal healthcare dollars is spent on diabetes, and approximately 90% of all diabetes costs deal with type 2 diabetes. So if you put that together, probably 1 in 5 healthcare dollars are spent on something that is probably largely avoidable by our population. But that's more of a political discussion. But in general, if we have somebody who's got diabetes or has some other type of illness, and we want to treat them, we're trying to encourage a value-based treatment and allow companies to work together, physicians and other providers to work together to create results. So we've got these updates, and they're essentially new exceptions under the Stark Law that were promulgated by CMS under HHS, and we've also got a few new safe harbors under the AntiKickback statute. The primary exceptions that CMS created is now if a value-based enterprise, and this is essentially participants who join together to create a value-based arrangement, if they take on full financial risk for the treatment of the covered patients, and this has to be for, it's essentially it's a target patient population, and what that means is it could be target patient population is a defined term, and I've got a few minutes to cover this, but I want to hit on a few things you need to be aware of. So everything that I have capitalized here in the slide: value-based activity, target patient population, value-based enterprise, and value-based enterprise participants. These are defined terms in the statute. So you have a target patient population. This could be by county, it could be by chronic illness. We have an entity who wants to, or an enterprise that wants to provide services for them, if they're willing to provide those services, and rather than a fees per service arrangement, do it as a entire coverage of services in a value-based arrangement, there are exceptions under Stark that allow for the physician rate referrals where they have a financial relationship. We also have another exception. There's a little bit different requirements that applies to a system where the physician's taking on not full financial risk, but there's a meaningful downside risk. And what that means is the physician is at risk to either forego or have to repay at least 10% of the total value of services provided. Again, this is to that target population. It's defined in a written document in advance. Aside from these two exceptions, we also have the general elements of a value-based arrangement, and this is again is a documented arrangement for the coordination of care for certain value-based activities that are stated in advance for a target population. Again, 600 and some odd pages of Stark exceptions and definitions, but that's the big picture. It's to encourage value-based arrangements for target populations. The modernized rules also clarified some commonly used terms, so fair market value. This essentially has been clarified so that it does not take into account the intended use. It's the actual fair market value of equipment or space, for instance. The definitions for commercial reasonableness, volume and value of referrals. There's clarification of the group practice requirements where physicians may use, if you have multiple physicians in a practice, the physicians can be compensated differently within the practice as long as the compensation is not positively correlated to the value or volume of referrals. And so that's a little clarification of group practices. And then these tie in with the anti-kickback statute safe harbors. So Stark, we have exceptions, AKS, we have safe harbors. But the big picture that I want to bring to your attention today is that if you have in the past, or if you are considering some type of value-based arrangement for a target population, if you've looked at this in the past and you had an analysis done by an attorney, and hopefully you would have the analysis done by an attorney, and you came to a conclusion that you could not do something because it would run afoul of Stark, I would encourage you to revisit that. That's really the big picture message. Revisit it, especially if it's something where you're thinking from a big picture standpoint, why can't we do this? Because this is adding value to the patients we serve. And really that's what we're trying to do. At a big picture level, the lawyers, the folks that are on the call today or on our video today, and the providers of these services, we're trying to increase the value of what we can provide. We feel better about what we're doing. And in doing that, if we think that in the past, the law prohibited what we wanted to do, go back and revisit. That's the big picture. All right, OIG also made some updates to the anti-kickback statute safe harbors. Several were updated with modernizing language. Again, it's all intended to create a system where we have where we're looking at that value-based arrangement. We're looking at achievable outcomes that will improve patient health and reduce costs, and moving away from the fee-for-service and getting into a results-driven healthcare system. We also see another trend was a few updates dealing with technology and electronics, updates with respect to electronic health records and cybersecurity. So you can, if you're in business dealing with cybersecurity technology, services, and hardware, and you're conducting some type of kickback statute analysis, know that there's a safe harbor and there's some exceptions in the law that account for new technologies. And that's, again, modernization of the law. We have 3 new kickback statute safe harbors. I've got a few minutes here, so I'm going to touch on these. And these, again, these are all the first in here, patient engagement and support. It's designed and it's intended to apply to value-based enterprise participants. I mentioned the cybersecurity, and then there's another safe harbor for CMS-sponsored payment models. So this is just a situation where if CMS happens to adopt a new payment model, we don't have to go back and amend the statute later. So they've captured this in this update statute. Several entities are not eligible generally for these services, but technology, cybersecurity services, and digital health companies. I've done an entire separate seminar on digital health. If you're interested in that, I think you can find it on our website or on YouTube. But digital health, this is another hot area, and there are exceptions for digital health. And with that, I've got just a couple minutes. I was going to finish with something fun. I talked about the asset protection. I was looking to see if I had any questions. Hopefully I have folks that stuck around. I caught the big updates that we are looking at, and I would like to know, what would you like us to cover in a future seminar? Would you like to hear about more on the updates to Stark and AKS? Would you like to hear about billing, audits, and disputes? I think that's going to affect a lot of people because it's going to affect the amount of money that their business is taking in. Or are there other issues that you would like us to cover? Please let me know on that. And I'll just finish here on give you some information with the big picture on asset protection. And we do several seminars on this as well. But what I want the takeaways to be today is that if you are in a high-risk profession and you're a healthcare provider, you're a lawyer, or some other area where you could be potentially sued, there are many steps that you can take, both from a corporate structuring standpoint and from a personal planning standpoint, to reduce your personal exposure and risk. And when you do that, it's not about hiding stuff. It's not reacting. You need to do this in advance. And when you do it, the benefit that you have is that it tends to reduce litigation. So what I've seen often now is whenever somebody is thinking about, whenever a plaintiff's lawyer is thinking about settling a claim, it could be a malpractice claim against the physician, it could be any type of claim where there's insurance on the other side, none of these folks ever want to settle these darn claims until they get a financial affidavit from the client. And the financial affidavit from the client, of course, if the client's got nothing financially, then they have no risk. But if the client gives them a financial affidavit that reveals assets, now what happens? Now the other side's going to want more. And you're kind of stuck in a tough spot. And so if you do planning in advance, and there's some simple things that you can do. You can, I'll touch on it here, creating different entities. For instance, if you operate a healthcare practice and you own the building, you should have separate entities that own the building and a separate entity that owns the practice. You should pay rent. It should be fair market value rent. You can get into more elaborate relationships where if you have particular intellectual property, you can license that to your business. If you have certain equipment, maybe you can license that. You might be limited to a certain degree depending on what type of practice. Dentists can only own dental practices, but with other healthcare practices, you can have non-physician owners. But understand that if you own different things, a business is only as valuable, a healthcare business in particular, is only as valuable as the services, the people who are providing the services, unless there are other physical assets. Take as many of those physical assets off the table as possible and do it in advance. We do this with entities. We do this on a personal level with trusts, but we have to do all of this stuff in advance. And that's my big picture for the takeaway today. Also understand the law gives you some freebies. Our Florida homesteads, certain wages and retirement plans, education plans, annuities, insurance, health savings account. There are places where you can put certain assets where they are going to be protected, even if you don't do anything else with them, because Florida law, section 222, provides that protection. And then there's some other ways you could title assets for maximum asset protection. So even if you're not inclined to do a lot of structuring and change entities, please understand that you can at least talk about some simple things that you can do. I kept this in really as a slide that I did with a financial advisory group, because I wanted to just send a message, and this was designed for physicians, but don't sit on your hands. The worst thing is having somebody come to me and they've been sued or they're in a lawsuit and they've got a bank account with $800,000 just sitting in it, and it's totally unprotected. That's totally unnecessary, and we can avoid that. With that, I am at my time 101. Thank you for joining me today. This was, I hope it was fun for you. We covered a lot of material. Let me know what you want to cover later. and reach out if you have any questions. Have a great day, and thanks again. Bye-bye.